Welcome to creating a criminal history evaluation tool for employment purposes. I'm Mike Coffey, President of Imperative Information Group. We're a background screening company based here in beautiful Fort Worth, Texas, but serving clients across the country. I'm an HR guy. I've been in and around HR for more than 20 years now. I had a HR consulting practice that a number of years turned into a background screening company. And so I still spend a lot of my time helping employers, especially in the areas of employee relations and recruiting and selection issues, especially on the selection side. But what our company primarily does are employment-related background checks. And so I'm privileged that I get to work with a lot of really smart HR people who bring some interesting challenges to me, and we get to work together and figure those out. And then usually what I end up doing is turning those into a webinar and sharing the wealth of really my clients' intelligence and wisdom. But all that said, I am not a lawyer, and I'm especially not your lawyer, okay? So whatever we say today, take back to your law firm, to your legal counsel, whoever you work with, and say, you know, here's what I understand, here's the handouts, here's what we think we ought to do. You may have some real state-specific issues that you want to be concerned with. You may also have some past history in your organization that maybe you've just got some knucklehead managers, and maybe your policies are written a certain way just to keep certain managers or you know, a certain kind of company culture from taking place. And so you do need to, there are times where just because you can do it doesn't mean you should do it, but at the same time, just because you've never done it this way doesn't mean that maybe you should consider doing it this way as well. So I'm going to provide you a lot of information today that's primarily just the gospel according to Coffey. It's my opinion about how things might be a good way, you know, to address some of the issues we're talking about. But again, I'm not a lawyer. I think I can defend everything I say, and everything I share is gospel according to Coffey, and a lot of our clients are implementing these things. So it's not like you're just field testing it for the first time. Whenever we talk about background checks, I think it's important to consider, why do we even care about an employee's background? And really, it's this slide should probably be called why do we care about employees' backgrounds, rather than why do employers run background checks? Because really, as we'll talk about later, the background check is just the very end of a long process that really should start with the job description and move through the whole application and interviewing process. But the short version is that you care about your prospective and current employees' past because they predict their future. And if they've done something in the past that suggests that they're either not safe or competent, or that they're just going to be a management headache, it can cost your company. It can cost your assets. It can cost you inside your workforce. Workplace violence is a serious issue. It can also affect you inside the workforce apart from violence, just by you know, the quality of the people you hire and that you have in your workplace affects the outcomes that you desire in your organization, and it affects the kind of people you can recruit and retain in the future. It also affects your reputation and the public's trust in your organization. When something goes wrong, and it's especially if it's workplace related, or you know, if it's a FedEx truck that you know, is involved in an auto accident, everybody who saw it, or if it's on the news, remembers it was a FedEx truck. They don't even know maybe what the driver's situation was, or what the backgrounds were, or what, you know, if there was litigation, you know, who was found liable. All they remember is that your company was involved in that incident. So public trust is probably one of the most expensive things to regain after you've had something go wrong in the workplace. So let's do a real quick poll here. I'm curious about how many of you have some sort of policy covering your use of criminal history information. So take a minute and answer that poll for me. And I'm not talking just about background checks. I'm talking about that says how you use criminal history information, what the applicants tell you, what you learn maybe from the background check, any point, not just the background checks, but and not a policy that says we do background checks. It's how do you use that criminal history information? How do you know if it's relevant? That's what we're going to talk about today. Okay, give you a couple more seconds. Okay, I'm going to close it. Let me share these results with you. Okay, so as you can see, about half of you have some sort of policy. That's good. About a quarter of you have no policy, and a quarter of you said you kind of sort of have a policy. And that kind of sort of policy is probably, you know what you're going to do with it. Your organization's got a history, a tradition of how you deal with different things. Maybe your recruiters or your HR compliance people or your loss prevention people, whoever is security, whoever's involved in that process. They know what they're going to do, but it's not recorded, not written down, and maybe it's not as consistent as you'd like. That's what we hear from a lot of clients. But as it goes, that's not uncommon for a lot of different employers. So we'll talk about today how to create that policy. And there's a couple different ways employers use criminal history. And one is the obvious one, and it's the one that we think of automatically when we're talking about criminal history, and that's just excluding certain applicants from certain jobs. You wouldn't necessarily want this guy on the left driving this forklift in your warehouse full of munitions. Okay, and it's a bomb on the front of that forklift. It's probably a bomb walking here along that white line there as well. But it's obvious there's certain offenses that are pretty recent that we're just going to eliminate certain people from certain kinds of jobs. And I'm sure in your organization you can think of a few of those that would do that. But the way a lot of employers use criminal history also, and I would suggest that you would want to do, is to look at how you use it in just evaluating candidate A and candidate B. If you've got two candidates and one has no criminal history, which slipped off the page over there, and the other one has no criminal history and one has some criminal history, that may factor in, even if it doesn't, the criminal history is not exclusionary, it's not something that would necessarily exclude this guy, it doesn't mean that it's not relevant in comparing candidate A and candidate B. And let's look at an example of that. Let's say you've got two candidates, and you got Dick here, and Dick's got 9 years of relevant experience, an MBA, neutral job references. He performed well during the interview, and he's got no criminal records reported. If he's honest on his employment application, then he has no criminal history. Let's say you've got Tom here. Tom's, he's almost identical to Dick. Looks really good, but a couple of years ago he had a theft by check conviction. And then in 2011 he had an open container violation. In 2009 he had a failure to appear. These are all relatively minor offenses that for many, many jobs wouldn't be exclusionary, wouldn't keep you from hiring Tom. But if you're going to look at Tom and Dick, and they're both your candidates for the job and everything else being the same, which one's looks like they're going to be easier to manage? Who's going to be your more compliant employee? Who's going to be the guy who is less likely to give you, to be your next employee relations headache, or for your management to spend more time managing? I would suggest to you it's Dick. And that's the way a lot of employers do this. We look at the criminal history just like we do everything else. Where did they go to school? What companies have they worked for? I know many employers have preferences for candidates out of a certain school or who've worked at certain other companies. There's a large government contractor in our area that's really well known for how well they train their recruiters. And so a lot of other companies, when they see somebody who's spent a good bit of time there as a recruiter, they know they've at least been given the opportunity to develop some really good recruiting skills. So this is no different. If you're looking at how they've managed their past behavior, it's going to give you some insight into how they may operate into your environment when you're comparing two different people. Now we'll get into some of the legality stuff on some of this in just a second, but if we're just talking strictly on a candidate-to-candidate comparison basis, in many cases there's no reason not to look at this information. I'd suggest you're missing an opportunity to evaluate your candidates well if you don't. So let's get into the legal stuff. Title VII of the Civil Rights Act. I've got a whole webinar just on Title VII issues, okay? So we can't cover all of that today. But what I am going to do is just touch on the high points so that you kind of understand the context of why I say some of the things I say. The Title VII created the protected classes we're all familiar with: race, color, sex, national origin, and religion. Other laws like the Americans with Disabilities Act, Age Discrimination and Employment Act, GINA, they created other protected classes as well. But the ones we're talking about today are primarily those Title VII categories, primarily race and color. Those are the two that are most of most concern when you're looking at criminal history, but also sex. The EEOC has claimed in a recent case, unsuccessfully, that because men are more likely to be convicted of criminal offenses than women are, the use of criminal history can be discriminatory against men. So, like I said, they weren't successful in that case, but that concept's out there as well. So there are two kinds of discrimination under Title VII. One's disparate treatment. We know that when we see it, it's that really ugly stuff that unfortunately still exists in some places, or because somebody's in this protected class, we're just not going to hire them. And and in some situations, employers think they're doing the applicant a favor, especially in the case of women working in certain chemical areas, and employers express concerns about their safety. But the courts have repeatedly said that's a consideration for the women, not the employer. So that's disparate treatment. And then there's disparate impact. And this all comes out of that Griggs v. Duke Power Company case, 1971 Supreme Court decision, that said you can have policies that on their face aren't discriminatory, but in their impact, they do create a disparate impact on people in a protected class, which is perfectly legal unless you don't have, as long as you have a business reason for that policy. So in the Duke Power case, what they had was Duke Power had a policy that said in order to become a manager or supervisor, you had to have a high school diploma and pass basically an IQ test or an intelligence test. That was a new policy, and basically, this is the South in the 60s, and it kept their African-American employees who hadn't, quite honestly, had the education opportunities because of the institutional segregation, and especially in the South. They hadn't had the opportunities to get the education and the high school diploma. And so regardless of how good of an employee they were or what other skills they might have, the policy that required them to have a high school diploma was preventing them from becoming managers or supervisors. Mr. Griggs was the lead plaintiff in the class action lawsuit under Title VII, and it went to the Supreme Court. And the Supreme Court agreed with Mr. Griggs and saying, they even looked at evidence that there were managers who were managers before they had this policy who didn't have their high school diploma, and their performance was no different no better, no worse than those managers who did have a high school diploma. So a high school diploma wasn't a predictor of future behavior and of success in the role. So that's where this idea of disparate impact, that wasn't originally written into the law. It was amended a number of years later and put into the law, but it originally was just a court decision, and that's where we really originally got the disparate impact idea. And then the Green versus Missouri Pacific case is another one. That was 1975, and it was a disparate impact case. It was not a Supreme Court case. It was an Eighth Circuit case, but what happened there was Missouri Pacific had a policy that said, we will not hire anybody with any criminal history at all, period. And so it didn't matter how long ago it was, what the nature of the offense was or anything. We're just not going to hire anybody with that, with an offense. Well, Mr. Green applied, and he had been a war protester in the 60s and actually served, I think, about 1.5 years, if I recall right, in federal prison because he refused to register for the draft and perhaps did some other things. And so he applied to work at Missouri Pacific, and they just, as soon as he, they saw any affirmative response to his criminal history question, they excluded him from employment. He sued, and the court agreed with him. And the Eighth Circuit said that, in fact, because in his case, African Americans were arrested, prosecuted, and convicted at a higher rate than the white population, any policy that in and of itself is so broad that it doesn't have a business justification. There's no reason for that. There's no reason that a shoplifting charge from 20 years ago should eliminate somebody from consideration today for most jobs. And so they didn't have a business justification for that policy, and it was very likely to have a greater impact on African Americans. And so the court, in their decision, laid out a number of items, the nature of the offense that employers should consider. They should consider the time that's elapsed since the offense and the nature of the job, how those things all relate to each other. Now you see these are called the green factors, and you see them listed like this as bullets or things that employers should consider, and employers should definitely consider these things. But it's important to know that the court was dealing, you got to remember, they were dealing with a completely bright line exclusionary policy that said nobody with any criminal history ever. They weren't looking at a nuanced policy that said, for this kind of job, we're concerned about this kind of conduct in the last X number of years. And in fact, every case that's been brought by a plaintiff since Green versus Missouri Pacific has been lost by the plaintiff. So the employers have won all of those cases, including the cases brought by the EEOC. There are 2 cases out there right now against the EEOC, and we'll see how successful they are in prosecuting those. But it's important to know, while this is what you probably should do, there may be other factors in your employment considerations, including what the rest of your applicant pool looks like as far as skills and abilities, before you determine that we're going to use just these three factors. I'd suggest that looking at the whole applicant's always a good idea. Looking at the job and the totality of the situation is really important. And so that's what you really want to do. You want to look at the whole applicant. What experience do they bring? What's their education, license history? What kind of skill set do they bring? What kind of soft skills do they have? Are they a great people person? Is this a sales role? Well, that's really important. And then look at their criminal history. You want to see all of that together. There are obviously going to be positions where you do exclude somebody just because of the offense. In the healthcare environment, sexual offenses, a lot of violent offenses, things like that, are going to keep people out of certain kinds of jobs. If you're in a financial circumstance, whether somebody's got access to a lot of cash or things like that, or their access to people's accounts, things like that, the certain kinds of fraud and financial crimes, maybe theft even, may be a real consideration for people in those roles, and maybe even be exclusionary without really any further consideration. But what you don't want to do is have a criminal records bright line rule. You don't want to have a policy that says clean background check required, because what you're doing when you post that in job posting or something like that, what you're saying is you're telling applicants with a criminal history just don't apply. No felonies allowed. That's another example that can sometimes cause employers problems, because even though it's a felony, what could be a felony in one state can be a misdemeanor in another. And so I would suggest that you want to look at the underlying conduct, and rather than focusing on felonies, let's look at the underlying conduct and what did they do, and what does that mean for this job. For instance, in Texas, your third DWI is a felony. If someone had their third DWI 10 years ago and they've had no other incidents with the criminal justice system since then why would you eliminate them from consideration for a position where all they do is drive a desk in your organization, right? It wouldn't make a lot of sense. So so when even something that sounds as serious as felonies might be a concern. And then no convictions for theft or dishonesty. There's recently been some cases against Wells Fargo and another bank for their policies, which are interesting because their policies are required by federal law, but that they can't hire anybody with any kind of theft or conviction for dishonesty. And so after the financial meltdown a few years ago, these new laws that were really aimed more at corporate executives and the people who caused the financial meltdown, they instead ended up impacting tellers at banks, because somebody might have had a conviction for theft or dishonesty 20 years ago. They may have worked for the bank for 10 or 12 or 15 years and perfectly good employees, but now under federal law they can no longer be employed. And so in the Wells Fargo case, Wells Fargo terminated those employees because they couldn't work there legally. And then the employees turned around and sued Wells Fargo. So, and the question is did Wells Fargo have a responsibility to help those employees go to the federal government, state their case, and try to get a waiver from the government? So these are overly broad rules that you probably want to avoid. In 2012, the EEOC came out with their new guidance on the use of criminal history. And again, I've got a whole webinar just on the EEOC guidance and what they want you to do. But basically, they want you to use those screen factors, the nature of the offense, the nature of the job, and the time that it's elapsed. Plus, they add in this other idea called individualized assessment. And basically what individualized assessment is where the EEOC believes that an employer has a responsibility, even though this isn't stated in the law, they believe an employer has a responsibility to give the applicant an opportunity to explain why your policy should not apply to them. In other words, tell you their side of the story, other circumstances surrounding the incident, what a good citizen they've been since their release from incarceration or since the offense, things like that. And then that employers should give every applicant who gets disqualified or whose criminal history hurts them in the employment process an opportunity to do that. And so in our webinar on this topic and on our webinar on creating your criminal history inquiry, we suggest that employers include that individualized assessment language and an opportunity for an applicant to provide their side of the story right along on the employment application with their criminal history inquiry. And that webinar is recorded on our website as well, and you can go look at that at any time. So the bottom line is, how might past behavior predict on the job behavior? What have they done in the past? It shows that maybe they don't have a safety sensitive awareness, or maybe they don't, they just haven't shown that they're an honest person, or they've shown a propensity for violence or loss of control, things like that. And what does that mean for your particular job? That's what we're going to try and talk about, how we predict those things. So let's do another poll real quick, see if you're awake. When do you inquire about applicants' criminal history? Giving you a few options there on the employment application, or at the interview, after the offer. Let's see, well, we're getting a few answers there. And like I said, I've got a whole webinar just on creating a criminal history inquiry. And it's recorded on our website. And there are a lot of state-by-state considerations you want to pay attention to there. Let me share these results with you. Okay, so you can see that 52% of you ask on the employment application. I would guess that 5 years ago it was closer to 75% of you. Larger employers, larger multi-state employers, there is a trend for them to remove the criminal history inquiry from the application, primarily because a handful of states and even some municipalities have eliminated when employers can ask about criminal history. Last week, the New York City Council passed a city ordinance concerning that. So at the state and even local levels, more and more regulators or legislators are making policies that limit employers' ability to do this. Now, the majority of states don't have such limitations, and you can still ask on the employment application, but I can see where, from just a logistical standpoint, a multi-state employer, and we have a number of those as clients, would have a challenge there. And so some employers are just saying, we're going to go ahead and push off the criminal history inquiry till later in the process, till at least after an interview. And if you're in Hawaii, it would need to be after you've made a conditional offer, in fact. So let me close that. And you may want to check out that webinar. And so now what we're going to get into is really gospel according to Coffey stuff. This is where I'm really going to get into it with you about ways that how we think here about criminal history when we're talking to our clients, and ways that maybe you can, as an employer, make more consistent and thoughtful decisions on how you use criminal history. The first thing I really want to stress is that your screening process starts at the job description. The background check is just, the very end of the process. But if you've got a good job description that says, identifies these are the risks inherent in this job, and then you've got a criminal offense relevance matrix, which we're going to talk about in a bit, that says before you ever ask the first applicant about their criminal history or you ever order the first background check, you already know for this job, these are the kind of offenses that are of concern. That makes your life so much easier as an employer. And then you've got a good employment application with a good criminal history inquiry. You've got a good interview process where you follow up on that stuff that's in the employment application, and not just the criminal history information, but you really dig deep into their employment history, the kind of experiences they've had, the kind of projects they've led, those kinds of things during the interview. And then you turn around and you conduct a background check to verify everything that you can that the applicant told you. And because the bottom line is, the employment application, the interview process, those are the least expensive integrity tests you will ever give your applicants. If they lied to you coming in the door, then how can you be surprised if down the road something goes wrong and you don't, either they don't tell you about something when you need to know about it, or they flat lie about something, or worse yet, or just dishonest about something and cause the company some sort of loss. All the background check should be is that lie detector test, that verification that the person everything the person's told you up till now is accurate. And the way the importance of that is giving that applicant every opportunity to be straight with you and to really reflect who they are and where they've been, what they've learned from the experiences they've had. And then we just go back with the background check and verify what we can. That's the ideal process. And so what does that relevance matrix look like? For a specific group of jobs, what we're suggesting is that you have really it could be position specific, but usually just more job class specific. You might have a set of rules for administrative clerical positions that don't have access to company accounts and never drive. You may have a different set for people in your accounting department who have access to company accounts, and maybe for any drivers, you've got another set of requirements to make sure that if they drive on company business, whether it's once a week or every day, that you're going to be concerned about their safety awareness, and offenses that look like they're operating unsafely would be a concern for you. So, and then it looks at the offenses and it says, based on the offense history, yes, they're eligible for hire, or they're, yellow light here, they're getting some sort of corporate review. There's, we're going to look at the whole applicant. We're going to dig deeper, ask them more questions about the underlying conduct and the outcome of the case. Then we're going to go verify those details to be sure. And then maybe security's involved, or somebody in, at a higher level in management needs to review that. And then there are going to be certain offenses where we say, no, you're not qualified for this job. I'll give you an example. I speak to former offender groups from time to time. These are, people who mostly have been recently released from prison and are preparing to start a job search. And the question is always for them, how do I ever find work with my criminal history? And for some of them, it's going to be obviously very difficult. And perhaps it should be for a lot of jobs. And I had a gentleman who's a few years older than me come up to me after one of these sessions one time, and he said, I'd like to talk to you about my history and see if you think I could ever find a job. And I said, well, tell me about your offense first, and tell me what your history looks like. And he had multiple counts of sexual assault of a child, and spent several years in prison for that, and was a registered sex offender. And I said, well, what kind of work have you done traditionally? And he said, well, I was an HR director when when all this went down. Do you think I'll ever be able to go back to HR? And I had to tell him no. He said, I don't want to work with kids. I don't have anything to do with any environment with kids. And I said, no, I can't imagine a situation where you could ever go back to HR, because if you're going to be an HR leader, you've got to be able to conduct investigations, and you've got to be able to counsel employees. You've got to be able to do some things that require a high level of judgment and credibility. And even if you were able to do all those things successfully, there's always a pretty good chance in HR that at some point an HR leader is going to have to go testify about the company's actions in a certain situation. And as the defense attorney for a company, I would never want to have to put on the stand my investigator or my HR decision maker with somebody with that kind of offense in their history. It just shows, at the very least, it shows just a tragic failure of reasoning, and at worst, it shows just really poor character. And it's the kind of thing that we just couldn't have a leader in our, in an HR role represent our, a company with. And so I told him I thought it would be a very challenging, forever probably, as long as he's a registered sex offender, very challenging situation for him to ever return to an HR role. And his best hope is probably to find a role with a company that doesn't do background checks, if that's where he's going. So what you get you do this evaluation, and what you end up with is something along this lines. You see that we've got a list of offenses down here, down one side, and then 0 to 3 years, 3 to 7 years, and 7+ years. You can see we've categorized these offenses. So this first one, alcohol consumption or possession offenses, you can see across the board they're eligible for employment. That's not something that's a concern for this particular position. Let's say this position was a salesman on a car lot, in a new car sales facility. Then you get in here, computer crimes. You can see they're yellow. We've highlighted them as yellow, but they're C. They're corporate review in this example. That's how they're targeting those. And so they're going to get some sort of corporate review, because we want to know what the computer crimes were. We want to dig deeper into what did he do, what kind of offense was it? Was it related to, we've seen them in our background screening practice here. We've seen those where we pull the files for clients and get deeper into what actually happened, and we see that, well, this was a divorce, and this guy, got into his wife's laptop and put, some sort of monitoring software on it, and it was just everybody gets a little crazy during a divorce and it's been several years, maybe it's not of a concern for this role. But for other roles, it may be a concern. I mean, that you may not want that the guy who's justified that in his head in the past being your IT administrator. But there may be other offenses where you say, well, computer crimes, you look into it and it's not something of concern at all, and you just want to get the details. And so you see a computer crime at any age for this position, because these people, you got to think about car salesmen. When they're selling a car, they've got access to people's personally identifiable information. They've got a lot of information about people who are buying cars, and so maybe you want to make sure that they're taking care of business, and they're not going to be somebody who's a real threat to you if they've got access to your computer network. And then you look at the third section here, the red one here, auto theft. And you know what? If you've been convicted of stealing a car in the last 7 years, we're probably not going to hire you to be a car salesman for us on our car lot. If it's more than 7 years ago, we're going to look at it. We're going to look at the offense, what you did. Did you steal 7 cars, or did you sell 50 cars, or 1 car? What happened? We're going to get the details and look deeper into it to figure out what happened and then how long ago it was. Because we're going to still use those green factors, the age of the offense, the nature of the job, and the time that's passed, and evaluate on a case-by-case basis these things that are C's, that are some sort of corporate review. But can you see how having this kind of policy in place makes your life a lot easier as the employer? Before you ever see that employment application with a response, you already know how you're going to respond to it. And please do keep asking your questions. I will get to all the questions at the end, and I will spend as much time as we need to answer them. So how do you get to that kind of relevance matrix? Well, there's a few tools that we've developed that help our clients do that. The first is this position risk review checklist. And so for a specific position, it looks at a variety of different issues. What kind of access does someone in this position have? Do they have access to personally identifiable information, company or client accounts, competitive information, computer networks, assets that are easily removable, things like that? Do they have access to other people's homes, workplaces, things like that, or vulnerable populations, children, the infirm? So you just go through and check those. And then what's their level of supervision? What kind of work environment do they have? Do they work alone? Are they closely supervised? Do they work with a vulnerable population? Do they work, what you might do considering, West Texas oil fields, where somebody working out there, you may not be a lot less concerned about certain kinds of offenses than you would if it was a call center environment or something like that. And then what are their job responsibilities? They handle cash, they operate a motor vehicle, they manage client accounts, all those kinds of things. So you go through and you check off those things that are relevant to that position. And this just kind of helps you get a risk profile for that job. Then you can take those things that you checked, and here they are all across the top of this spreadsheet: access, supervision level, and further out over here to the right would be the other categories. And then down this side, and so you've marked the ones that you marked on the previous sheet as relevant. So you said this is relevant, this is relevant, this is relevant. This one wasn't relevant, this one is relevant, that one's not, that's a risk, that's not relevant. These are risk areas that aren't relevant. So you can see, you've marked them here as relevant columns. And then we look down and we try to figure out, okay, for these large, broad categories of crimes, are those offenses related to these specific kinds of risks? So you see the first category, they've got access to personally identifiable information. Okay, so if it's personally identifiable information, people's social security numbers, dates of birth, name, things like that, we've marked yes, they do have that access. So then you can move down that column. Does that kind of access, does that cause any concerns if someone has offenses for crimes against people? Murder, rape, sexual assault, sexual harassment? Probably not, because that offense doesn't really relate to identity theft or having access to PII, just generally. Now, you could make an argument in your environment. we're always dealing with, in our environment, 80 or 90% of our women who are local, and this person has access to their names and dates of birth and addresses and things like that. And you might say, you know what, any kind of sex offense, we're not going to have, because our clients are primarily female, that is a concern. But in this example, the company just determined that there wasn't a connection there. But then you get down to the next one, financial crimes, fraud, embezzlement, credit card abuse, things like that. They said, yes, definitely, because we've got that kind of offense ties directly to having access to PII. So this is a time-consuming process, believe me. But once you do it, you really get a pretty fleshed out area that these kinds of crimes are probably somehow related to this particular job. And let's say in this case, it was an IT manager position. So you just do that for each column that you marked as relevant, and what you end up with is kind of a pretty good risk profile and an idea that which kind of offenses you're really going to be concerned about. And when you see a whole bunch of offenses for a specific position, a certain kind of class of offense has a lot of check boxes, this is a higher risk offense for this job. And then you can take it over to our offense matrix, and you can see crimes against persons, financial crimes, property crimes down here. All these different categories of offense are on one side, and then the details are in the next column there. You see the first one, assault and battery, domestic violence, child abuse, molestation, child neglect, child endangerment. And so you've got all these detailed offenses. Then you can start to, as an organization, go through and say, okay, these crimes against person, in general, if they've had this kind of offense in the last 7 years, then let's look at assault and battery, domestic violence. You can see that we said if they've had any of those convictions at all in the last 7 or more years, we're going to look at the details of those. And for most violent crimes, you probably want to do that. You want to know what really happened, regardless of how long ago it was. You really want to understand the context, and you want to get deeper into how long ago did that offense happen? How long ago were they released from prison or jail or probation? Because if they were on a pretty tight leash or were incarcerated for the better part of, even if the offense was 15 years ago, but they've been out of jail only 3 years, then a 15-year-old offense may be relevant, because only 3 years of history to demonstrate that they're able to operate independently may not be the level of comfort that, it may not give you the level of comfort that you want to put somebody in certain kinds of positions. And then so you just go through line by line, but you can see that we said down here, when you get down to indecent exposure, kidnapping, manslaughter, any of those in the last 3 years, we just said, no, we're not going to hire somebody as an IT manager who's a manager, a supervisor in our organization, who's got some sort of leadership responsibilities. If they've had those kind of offenses in the last 3 years, no, they can't be in that position. This is an example. Again, this is sample only. You'll have to think about in your organization what controls are in place and what the risks are for a specific job in your organization. But once you've got this put together, here's your policy. So as soon as you see that employment application, you know what your response is going to be. So let's walk through a couple other circumstances that come up. You'll hear when you're talking to applicants all the time, well, my lawyer said that wasn't going to be on my report, or that wasn't going to be on my record. And what they're really telling you is, well, I lied to you on my application, even though you asked the right question. I thought I could get away with it because my lawyer said you wouldn't ever find out about it. Well, and that probably tells you everything you need to know about their integrity right there. But it's probably true that their lawyer did tell them that. My best friend is a criminal defense attorney, and I know a lot of criminal defense attorneys, and whenever we have these conversations about employment background checks, they're always surprised that employers see things like deferred adjudication, or that employers even care. And I'll give you an example. Deferred adjudication means, in most states, that the person pled guilty or no contest to the offense. So they've accepted responsibility for the offense, and then they serve probation, and at the end of the probation, the case is dismissed. But if they screw up the probation, the court can enter their guilt, enter their plea of guilt or no contest against them and convict them immediately. And so they've taken definitely that's taking responsibility for the offense. At the end of the case, though, if they've successfully completed the probation, the case can get dismissed. Now, a lot of people, there's a lot of theory out there, and you hear a lot of, just HR conversation, myth maybe is a better term, that employers can't use dismissed cases. And that's not true. In a few states you can't, that's true. In a handful of states you cannot, but in most states and under federal law you certainly can. And under Griggs v. Duke Power, or even under Green versus Missouri Pacific, you can use dismissed cases. Even the EEOC says you can use arrest records. And you hear all the time, well, it's illegal to use arrest records. In a few states it is, but in most cases it's not. But what the EEOC says, and makes sense, is that it has to be reasonable for the employer to believe that the person engaged in that conduct. So just the fact that somebody's arrested doesn't mean that they actually did anything. So I wouldn't ever suggest that if you come across an arrest record or a dismissed case, you assume that the person engaged in that conduct. But certainly if they pled guilty, if they serve probation, and the case is dismissed after they completed probation, then it's probably reasonable as an employer for you to consider that information in making the hiring decision, because your concern should really be, just like when we're talking about misdemeanors and felonies, the same goes for the outcome of the case. Your concern should really be the underlying conduct, and what does that conduct say about their fitness for this job? Not, did this guy have a really good lawyer so he got deferred adjudication, but this other guy didn't, he got a public defender and he had to plead guilty and he served jail time for the exact same offense. That, if you're really concerned about social justice, that's the issue you got to be concerned about, is how broken our public defender system is. But the fact that one guy had a better lawyer than the other guy probably shouldn't factor into your employment decision, but it will if you ignore deferred adjudications and things like that. So if it's reasonable for you to believe they engaged in that conduct, then it makes sense for you to evaluate that information as part of the evaluation of that applicant. But this also means that you need to be working with a background screening company that can go get additional information for you, who can, in a reasonably quick period of time, pull court copies for you and get you documents so you understand the context. I would suggest you never want to make a hiring decision on anything that you really don't understand what happened in the case. If you don't understand, if a conviction's easy, deferred adjudication is easy, but you may see something that's dismissed at the request of the complaining witness, and that's something that happens in domestic violence sometimes. He comes home on a Friday night and has a few drinks and starts beating on his wife. She calls the police to get her, to get them to come get him off of her. The police show up, they put in their police report. She was crying, had a bloody nose, he was screaming and ranting, and they carry him off to jail. Sunday morning comes around, she doesn't want to prosecute, she doesn't want him to stay in jail for whatever reason, and she goes down to the jail and gets him out. She tells the district attorney she's not going to cooperate, doesn't want to press charges, won't cooperate with his prosecution, and the case is dismissed at the request of the complaining witness. We see that on occasion. You may see 3 or 4 or 5 of those kinds of cases are all dismissed at the request of the complaining witness, and you start to see, though, there's a pattern here. So what we would tell our clients is, don't make the hiring decision based on those, but let's go get more information. Let's get those police reports. Let's find out what happened in any court settings they had. Let's get the details so you really understand the full context, because there may be certain positions, working with the infirm or special needs kind of clients who, would tend to, perhaps make somebody with a short temper or a tendency to explode, probably would not be a good person to work in those environments. Or maybe that's not the person you want on your customer service desk at Target the day after Christmas, something like that. So maybe you look deeper into that conduct and see what they really did. Is it reasonable for me to believe they did that? Well, when you see multiple police reports and police narrative that say that, yes, this is what this person did, and you see a pattern of that, then maybe you can make a decision based on that. It's reasonable for you to believe, because you don't have that standard. Let me say this, you don't have that standard as an employer of guilty beyond a reasonable doubt. As an employer, it just has to be reasonable for you to believe they engaged in that conduct. And that's a lot lower bar because you've got a lot of other factors to consider as far as who you're protecting and the roles you need, the jobs you need accomplished. So misdemeanor or felony, we talked about that a little bit earlier. I recommend that employers don't focus on misdemeanor or felony classifications. Like I said, what could be a felony in one state is a misdemeanor in another. There's, in Texas, statutory rape, sex with somebody under the age of consent, is a felony. In Louisiana, it can be a misdemeanor. And so if you weren't considering misdemeanors, but you were hiring somebody to work with teenagers, you might miss that offense that you really do care about. So I would suggest that don't look at misdemeanor felony as much as you look at the underlying conduct. What did they do? Which means, quite honestly, you've got to think a little bit more than you might otherwise, do, by just looking at, it's a felony, we're not going to hire them, or it's a misdemeanor, we don't care about it. I'd suggest you want to dig deeper. Okay, let's do one more poll. How do you treat pending cases? If somebody's got a pending case, what do you do? What do you tell them? Do you consider them at all, or do you ask the applicant to reapply after they've after the case has been settled, or how do you handle that? A lot of you have said other already, so that's interesting. Maybe that's a case-by-case basis, or some of you said it depends on the hiring manager or the job. Give you a couple more seconds there. Okay. While pending, we consider them as convictions. Nobody has clicked that one yet. Okay. Okay, I'm going to close it now. Okay, so I'm closing it. Let me share those results. And you can see 41% of you said it depends on the hiring manager or the job. If it depends on the job, I think that's probably smart. That's like what we've been talking. If it's the hiring manager, I suggest you don't want to do that. Don't let your hiring managers make really arbitrary decisions. If you've got a policy that says certain kinds of conduct are of concern, you already know what kind of conduct is of concern for you. So don't let your hiring managers in this kind of information make an arbitrary decision, because they're going to be inconsistent and they're going to open you up to a claim of disparate impact or disparate impact, and they're going to say that you're having an unfair impact on minority candidates if in your area, like most areas, minorities are still arrested, prosecuted, and convicted at a higher rate than the rest of the population. So I would really suggest that you not do that. Let your hiring manager do it. 10% of you said we do not consider them at all. 13% we ask them to reapply after the case has been resolved, and that's a pretty common response. And depends on the hiring manager or the job, then other. I'm curious what the other is. That's all kinds of different things we get from employers, but I'm going to hide this, and we're almost done, so I'm going to get out of your hair here real quick. But let's jump over to the next slide. Pending cases, the way, this is gospel, let me say again, this is gospel according to Coffey, and absolutely none of you do this right now. When I say 0% of you treat them as convictions, at least until the case is closed. That's how we suggest you do it, though, and I'll tell you why. If the concern is that the person has engaged in that conduct, you want to get into, I would say, before you have them provide or have your background screening company pull court copies and understand what the underlying conduct was. Okay, if there's a pending case, in most jurisdictions, a magistrate or some sort of judge has looked at it and said there's probable cause to believe that the person's engaged in that conduct. And I just think if you're, and then I would take that case information that you get, understanding what the underlying conduct was, and then look at your criminal history policy. And if you've got a matrix like we talked about earlier, and it says if somebody's had a simple assault case in the last 3 years, they're not eligible for this this job in, facing the public in a high stress situation, if somebody has a pending case for that same offense, I would suggest at the very least you tell them, right now we're going to treat it like a conviction. We're going to assume you've engaged in that conduct. If the outcome of the case is different and we've got a position open in the future, you can reapply and we will review that. And then you can review it in context of the outcome of the case and what additional information is available to determine if it's why it was dismissed and if that makes any difference to your consideration. But think about it from this point of view. The other issue we want to think about is if the person's going to serve jail time, how might that affect their ability to do the job if they're not available for work? And that's the other consideration you have to have. If it's an offense where they could actually, lose their freedom and not be available for work, and you're about to spend the next 30 days, 60 days, 90 days training somebody, what's the cost of that? It's outrageously expensive to bring on a new employee. You probably don't have even good metrics in your organization to figure out what it really costs you and lost productivity from their peers, from the training effort and all those things. But it's very expensive, as I'm sure you recognize, to bring on a new employee. If somebody's got a case that's supposed to be disposed in the next 90 or 120 days, do you really want to take a chance on them not being available for work after you've invested all of this in them? So it's perfectly legal in almost every state. I can't think of a state where it's not acceptable to consider pending cases especially if the offense is relevant to the job. So by the way, if they're a current employee and they get arrested, we've got a whole presentation that I also do on what to do when an employee gets arrested, and it goes along the same lines, but it talks about how to conduct the investigation and how to communicate and all those things. So if they've got a warrant for their arrest, what do you do? I've had clients who've ignored even warrants for traffic warrants and things like that, and they've always regretted it. Make sure they take care of their business. That's probably a big red flag, even if it's just traffic warrants. You say, oh, he doesn't drive. We don't care if he's got all these traffic warrants. This guy is telling you by his driving history, I don't take care of business. Okay, that's if you want. I'm not going to be a reliable, steady employee. And quite honestly, one day they're not going to be available for work. What's going to happen is they're going to go out for lunch one day, get pulled over for something, running a stop sign or speeding or whatever, and those warrants are going to turn into an arrest, and this guy's not going to be available for work. Make them take care of their business. I'm not saying exclude somebody because they've got a warrant, but just say, hey, you know what, we're going to give you 7 days to take care of this. And if they can't get those warrants lifted, then there's something else deeper going on, and this is probably not your best candidate. When you see people who've had conspiracy to commit an offense, basically what that means is they tried to do it and they weren't successful. So does that really make a difference for you as an employer if they were just not a good criminal? They're not a very competent criminal. Does that make a difference? Probably not. I would suggest that anytime you see conspiracy or attempted charges, treat them just like they engaged in that offense, because they've, their intent was there. They just needed more practice before they came to work for you. And then you remember Otis from Andy Griffith. Otis was well, we used to call him the town drunk, but now under the ADAAA, he would be the town individual perceived to have a medical condition that's protected under the ADA. But anyway, he was, if you remember Otis, he was the guy who was just dragged and Andy would drag into the jail every now and then just to sober up. Well, would Otis be a good employee for you? And I'm not talking just because of his alcoholism, but just because he was consistently in jail, constantly having problems. And so when you're writing your policy, you want to think about how many offenses are of concern, even if the offenses themselves aren't of concern, the underlying nature. But I see this pattern of just bad decision-making, poor behavior, not taking care of business, just this consistent pattern of those things. Then maybe we want to reevaluate this person, and maybe we don't want to hire him, even though his conduct isn't directly related to the job, but his overall judgment and ability to manage his own life is reflective of how he's conducting his business. And remember that some states do have some local and statewide laws that are going to affect your considerations, not just on the background check side, but even what and when you can ask. And we've got webinars that cover all those things. And certainly your background screening company should be working with you if you're a multi-state employer or in the states you do operate in to make sure that you're following those laws. I mean, we've got clients in San Francisco who, just for the city of San Francisco, and now New York, I mean, we're going to have really specific requirements for those local cities. So you want to make sure that you've got a resource, whether it's your background screening company, your employment law counsel, or whoever, that can help you really figure out what considerations you need to pay attention to. And finally, it's going to say it one more time, look beyond exclusions. Look at the whole applicant and what is this person's criminal history, even if it's not exclusionary. What does it tell you about him, and how does it help him compare to the rest of the applicants that you've got for your position? And finally, did you learn something today? Is there something that you're going to take away and take some action on? Just give me a yes or no, please. This kind of helps me evaluate whether I'm wasting my time or not, or wasting your time, even worse, right? So give you something to think about. Okay, a few of you, about half of you voted, and about 60% of you vote on each one of these, and the other 40% I think just went to lunch and they just signed in so they get the credit. Okay, close. So I'm going to share that. Okay. 98% of you said, well, GoToMeeting's not very good at math. 98% of you said yes, and 3% said no. So I'm not sure how that works out. But so 3% of you, I owe a Starbucks card or something too, because I just wasted an hour of your time. But the rest of you, good. Thank you. I'm glad it gave you something to think about. And now let's go to questions. If I can go there, there we go. Let's look at these questions here. Let's see what we've got. Okay. Hi, Mike. What do you recommend for Texas employers as far as when to ask about the criminal history question? We collect the application with that question at the time of interview, but are going paperless and want to put that into our ATS. Should we ask for that after a successful interview? Now, if you're in Texas, I would say ask it right up front. Just like you ask the reasons for termination and other negative information, potentially negative information about them. In Texas, there's no law that limits an employer from asking that question later. Now, if you were going to hire positions, Tricia, that were going to be based in other states, if the job itself was located in another state, then I'd say let's look at those states' laws. And Tricia, by the way, is one of our clients, and so I know she would come to us if they had special state concerns, but we would we would want to make sure that we look at in those states what your concerns are, and then you'd have to decide, do we want to have a specific, especially with it's easier with an ATS, because you can have an employment application process that's based on where the position is located. So you could, in most ATSs, you could pretty easily say this position is located in California, so we're going to follow this process. This position is based in Texas, and we're going to follow this process. And so you could ask the criminal history, make the criminal history inquiry at the right time according to what the state laws are. But in Texas, and in any state where in most states you can ask on the employment application still, I would say go ahead and do it. Now, the other thing I'll say is go watch my criminal history inquiry webinar. And don't print a whole bunch of employment applications. If you've got your criminal history inquiry on the application, don't print a lot of them, because state by state it is changing. And I think the trend is definitely to move to asking about criminal history after an interview. The idea is that employers can't be trusted to know this stuff beforehand, because we're just too discriminatory and we're excluding too many people from employment because of their criminal history. But of course, if you have good policies, it doesn't matter when you find out about it. Your policy already has told you that this offense is exclusionary. We're just not going to hire them for this particular job because of when and what the offense was. But, or, you know, and if it's not exclusionary, it's something that you're concerned about, but it's not exclusionary, then you probably need to give them an interview anyway, just to make sure that you understand the whole applicant and everything that they bring. And if you've got those policies, having an interview with them should not make, just because they're more charming in an interview, should not make you change your policy. And that's kind of the idea behind the whole ban the box movement. I think, you know, what they really don't say is, you know, they expect employers to be so impressed by a candidate that they will ignore their own policies about criminal history. And I just don't know any employers that would do that if they've got good policies in place. And certainly I would advise any of my clients against it. Several questions about, will we be providing the presentation later? Oh, certainly we will. You'll get an email later on this afternoon, hopefully. Check your spam filter, because it comes out of our constant contact account and may end up in your spam filter. But it'll have a link for you to do a survey, a more complete survey, to give me more feedback about what you thought of the presentation. And at the end of that, we'll give you a link to download the slides, to watch the recorded presentation, and you know, certainly to have more information about imperatives, processes, and what we do. And let's see if we have more questions. Okay. Oh, one employer who said other on the pending cases said that the reason for other is because we aren't doing background checks at this time, so are unaware of pending convictions. Okay, well, that would do it. And if you need background checks, I know a really good company down there. There's a phone number on your screen, and we'd love to work with you. Can the position review checklist, risk review matrix, criminal offense matrix for employment purposes be purchased separately for use as a guide or only as part of a service package? So I think what you're asking me, Sharon, is will I share that stuff with you? And yes, I will. Even if you're not one of our clients, I'll share it with you. The danger is, and you'll get it actually if you'll download all these slides later on, you'll get it. You'll get those. The real trick is the consulting, because I really want you to be cautious in how you use those things. But I'm available for consulting too, and if you're not an imperative client, we have a fee for that. But I'll be glad to share the tools with you, and if you want to call and just talk through a few of them, I'm glad to help you with that too. Because Imperative has absolutely no salespeople. I'm as close as we have to sales, and I hate sales. So our policy is kind of, the fewer people who think we're jerks, the better off we are. And so we try to be, nice guys and put people to help people, help employers know what they need to do, and then hopefully they'll trust us in the future when it's time to talk about background checks. How do we get to your webinars? Jim, those are on our website. You'll get an email later on this afternoon with a link to one of them. But on our main website, on the Imperative main website, there's a, let me just pull it up here. Let me look at this. Pull this up. I'm looking away from you because I've got two monitors here. So let me see, imperativeinfo.com. And so on our main webinar, or on our main website, once it loads, right here under live presentations and webinars. Well, there it is. Let's go. You can see all of this. And here's my human resources webinars. And you click on that. And each of the topics are here, and you can click on any of the topics, and it'll take you to a page where you can actually watch the video or download even the slides and things, if it ever loads. So I'm competing with bandwidth on GoToMeeting and loading this website, but so you can see here, this is the introductory webinar on what employers need to know about background checks, and just kind of a high-level overview. You can watch the recording, and you can download the slides right here. So that's how that works. Hope that helps. Okay, that's all good. I think that's all the questions. So I appreciate everybody sticking around. It's 2:10, so you stuck around for questions longer than we were scheduled, but I appreciate that. And if you have more questions, my email's up on the screen. You'll get an email from me later. You can call me or shoot me an email anytime. I'm glad to help, because like I said, We're really a different kind of background screening company. I'm an HR guy who's been in this business now for 16 years with in screening, owning a screening company, and we approach everything as an HR function. And so we're doing for you what we don't think you should have to do for yourselves as HR, which means that the kind of things you deal with in your background screening process, where you have to call your background screening company, and if you can get hold of somebody, ask questions about what does this mean, I don't understand this, or why is this taking so long, we take care of all that for you. All our processes are built around getting it right the first time and delivering information that you can understand and that is actionable right away. So if you're not getting what you want from your current process, we'd love to talk to you about being your background screening partner. Other than that, look for the email later this afternoon. It should be in your inbox. Check your spam filter if you don't have it. But if you don't get it, shoot me an email back, and I will make sure you do get it, because sometimes it gets lost in the ether. I appreciate everybody spending so much time with me today. If we can ever be of service, give me a call. Thanks a lot. Bye-bye.